So, how are you all? Fine, good. So, the judiciary we were discussing about, and in judiciary we have discussed PIL, judicial activism, and the fast track courts we have discussed. Fast track court, I did not give the dictation, not discussed, and Lok Adalat also. Per incunium was the last uh, concept that I discussed. Okay. So, what are the other mechanisms apart from Supreme Court, High Court, and District Court? If we talk about District Court also, apart from High Court and Supreme Court, which are going together because the collegium system and removal system is the main, you know, uh, main matter related to Supreme Court and High Court. Apart from it, the jurisdiction that we discuss and that we have discussed, that what all jurisdiction is available only with Supreme Court, not with High Court, and with both. So the jurisdiction available with Supreme Court are number one, number one, the original jurisdiction. Yes or no? Under which article? Right? Then it is a court of revision. It can revise its own verdict because there is no other court above it. If it is to be, if the decision is to be revised, then no, the court of revision. So article 137. Then the highest court of appeal, but the appellate jurisdiction is shared with the High Court also. Article 133 and 34, matlab 134. Civil and criminal. You have taken a note of it or not? Yes. And the president and vice president elections, Supreme Court is the sole arbitrator. An original jurisdiction of related to Article 131 is for what purpose? Federal dispute for center-state relation, or if two states are fighting with each other, then Supreme Court will hear it. This is the original jurisdiction. Then both the courts are court of record. So it provides for what? Contempt jurisdiction. Yes or no? So if there is a question in the exam that what all types of jurisdiction we have in Indian judiciary and what are exclusive jurisdiction available with Supreme Court, will you be able to tell it or not? If you talk about the analytical question, then they will ask the jurisdiction is expanding day by day, that is enjoyed by the judiciary, but it has not been granted nor defined in the constitution. But again, you will tell that what all jurisdiction the Supreme Court and High Courts are having. Yes or no? Then the newer jurisdiction are coming up. What are extra judicial powers that Supreme Court is having, the High Court is having? by way of PIL, by way of judicial activism, by way of expanding judicial review, by way of increasing list of basic structure. Maybe new provision is included in basic structure, it means jurisdiction is more now. This is the matter that we will put in the expanded horizon of jurisdiction. Jurisdiction means what? Jurisdiction means the authorized area of working, right? Hmm. नहीं, कुछ of course judiciary will declare it, but with kind of convincing factors. Oh, DPSP is not enforceable. Judiciary has already told that balance between DPSP and fundamental right is part of basic structure. Balance, but not part 4. But balance between part 3 and part 4 is part of basic structure. Now, when they have said the balance is there, now all the fundamental rights on one side, like this is the balance. Balance is like this or not? And this is the fulcrum. So, fundamental right and DPSP. So, all the DPSP, all the fundamental rights. So, indirectly, they have included all the DPSP. But they cannot say explicitly that all DPSP are part of basic structure. Yes or no? Now, apart from this, the writ jurisdiction also I told. Yes or no? 32 and 226. We'll take a note of it. Now, the district court, I told that article 233 to 237 are there for the district court. This is called as subordinate judiciary. And in district court, the senior most judge is called as district judge. District judge. And there are two types of court in the district or at the district level: civil court and session court. In civil court, the civil offense cases are heard. In session, criminal cases are heard. Criminal cases are heard. So, crime and civil offense, right? In India, in Indian jurisprudence, the offenses can be civil offense or criminal offense. For civil offense, we are having Civil Procedure Code, CPC, and for criminal offenses, we are having CRPC, right? So the case is being heard between CRPC and CPC, and the punishment is given as per IPC, Indian Penal Code. So this is the basic platform on which the police function, the punishment. IPC is invoked by the police people while registering the FIR. Yes or no? 307. What is 307? And 302? Murder kind of thing. 302 to 307. And CPC and CRPC. So for example, CPC can be invoked if you have not deposited your tax, if you have stolen something, you have not paid the debt in time, you have pulled the chain of running train, civil offense. Criminal offense means you have necessarily assaulted a person physically, or you have mentally tortured someone, you have emotionally blackmailed. These all are crime, right? So crime necessarily give sufferings to the body directly, but civil is not giving the direct suffering to the body. This is the basic difference, and that is why the civil cases are postponed, are lying in the court for years, not decided. Say for example, the land dispute case is a civil case. Yes or no? Now there are civil cases related to matrimony, equation, the family property dispute. It is also a civil case or not? Then the adoption case, adopting a child, it is also civil matter. So for civil matters, the court is the nodal agency that can solve the purpose, means solve the issues, or we need to have some other body which is dealing the issue in a social manner, not as per the law. Because between Tanu Vets Manu, you know Tanu Vets Manu, the movie, very good movie it is. Tanu means lady, wife, and Manu means husband. There was a movie, very good movie. There is actually. So they are fighting with each other, and there is a person sitting. The person who is mediating the fight between husband and wife is judge or any other person. Hmm? Who is he? Psychologist. So who has, means they are paying to the psychologist, or the psychologist has been appointed by some authority from government side, huh? By some of the authority. So there is something called as, means extension of it is Lok Adalat for the civil matter, not the criminal matters. Lok Adalat. Lok Adalat in English, people's court. People's court to provide justice at your doorstep. At your doorstep, the justice will be given. So what happens? Say for example, two guys are there, two brothers are there, husband, wife, whatever. The problem is there. Nahi rehna. We will not be living together, whatever. So they have registered the case. Now the court will refer the case to Lok Adalat. Now in Lok Adalat, either the retired judges are there, the serving judge may also be there, and the members of the society who are accepted by the society as the gravity people. Gravity people are appointed in Lok Adalat. Appointed in Lok Adalat. For example, a retired professor, even retired judge, retired IAS, living in the village, leisure time with family in old age. So one is having good experience, and if one has rendered good service, number of years in service, then one may understand the things also. And the Lok Adalat has decided that you will be living together and you don't want to live together. So what will they do? They will be referring the matter to a psychologist. Psychologist is paid by the government. And what they say, that Lok Adalat and the court is giving you 6 months time. There will be 3-4 counseling sessions in between. One of the session was shown in Tanu Vets Manu movie. To understand that whether the the matter is beyond the cutoff or within the cutoff, that they can be brought together, right? So that's the issue. It's fine. Okay. So Lok Adalat is not guided by any law. Lok Adalat is not following CRPC, CPC, IPC, nothing. The decisions given by Lok Adalat cannot be appealed in any court of India. You see this? Either you accept the decision of Lok Adalat, that Lok Adalat has decided that you will be living together. Go. No divorce granted. There is only one thing possible. Either you accept it or you reject the decision given by Lok Adalat. Then Lok Adalat decision will be given to the court, right? And in court, if you accept it, then the judge will say, okay, go, whether divorce granted or not. If not, then what will happen? You will put a fresh case, you will register a fresh case in court, not appeal against the Lok Adalat. You will leave it as it is there, and then the fresh course will be registered in the district court. Then if you are not satisfied at the district level, then you will appeal in High Court, and if not High Court, then you will go to Supreme Court also. हाँ, बहुत सारे केसेस हैं, बड़े केस हैं. टाइम नहीं है, मतलब टाइम बहुत सारा है, पैसा भी बहुत सारा है, तो ठीक है, लड़ रहे हैं. What was the case for Shah Bano? A very good lawyer from Indore decided to live with another lady, and the first lady was accepting another lady for years, but one day lawyer told that I will not be giving you money, nor you can live in my house, please leave it. Then there was only one option, to knock the door of the court, right? Then the alimony issue. In Muslim, when I will discuss about Uniform Civil Code in detail, Article 44, then I will tell you that what all things are there, but otherwise that detail is not required. I'll give you only that stuff which is sufficient to top this exam. That's it. Not to do the PhD in that. So in Muslims, breaking of the marital affairs is not a big deal, because it is a contract. In Hindu religion, it is one of the aspect of pro and afterlife, right? So this is not possible. It is not taken that way, that easy. So when contract is over, or the contract has been disobeyed, then very small punishment is there in terms of money. That's it. And so is the property disputes. Now, when the Lok Adalat is not guided by any law, one of the Lok Adalat in MP gave the decision to a Hindu man that he was having 2 wives, then he will be living with one wife for 15 days of the month, with another wife for 15 days of the month. In Madhya Pradesh, in 2013 or 12. Now apparently prima facie it is not looking very convincing, means it's not taken very convincing, but you see, when they heard the case, the mistake of the first wife was there. That one lady was suffering from the kind of terminal disease, was not informed to the person whom she was married to, and after marriage man came to know about the cancerous state, and one had to spend a lot of money for the treatment purpose, and then the whole economy of the house was into the shattered state. And then what happened? The person went to the other girl whom he had affair before marriage, and because of the emotions, the the other girl did not marry or did not settle down, and she, out of empathetic component, she shifted to his house, looked after the first wife, looked after the children also out of the first wife wedlock, means the first wedlock. And then everything was fine in 5 6 years. When first wife got all right, she started bullshitting the second lady, right? Then it means the first wife used the second lady, and when the use was no more left, means no more use was possible, and she was all right, then she said, please go out of my home. So then the matter was there. But the matter of the fact was that the man was saying that I will also be going with the second lady. The childrens of the first lady were also saying that we will also go with the second lady. So it means the relationship is not guided by law. It is out of the emotional threads developed in a period of time. So that's how the Lok Adalat is seeing and looking at the cases. The another advantage of having Lok Adalat is that it is working at the regional level. The language problem is also not there because the local people are hearing the case, understanding it, right? The another advantage of Lok Adalat is that no money is taken by Lok Adalat. Even if some nominal amount has been collected, it is refunded back. Another issue is that you need not to have a lawyer for Lok Adalat. If at all lawyer is required, lawyer is provided by Lok Adalat. But the criticism of Lok Adalat is that the number of cases are inflated to create the artificial vacancies. And the already decided case in court are referred to the Lok Adalat so that the judicial importance and vacancies can be there more. Then the lawyer who worked at the court level is also assisting the parties in the Lok Adalat and taking the money. Then another criticism of Lok Adalat is that the Lok Adalat is pressurizing the party for what they want, or the indirect undue pressure is there through the Lok Adalat, because the members are in open touch with the society people. They are not like the judges. This is the criticism of Lok Adalat. Then Lok Adalat experience is mixed in the states. In some of the states, the success ratio is very good. But in other states like UP and Bihar, the success rate is not that good. The success has been seen for the Lok Adalat in Rajasthan, in Himachal, in some of the southern states, including Kerala and Tamil Nadu, but not in UP and Bihar. Right? Now, the civil and session court, basically what happens that in the criminal side of the court, we are having the class 1 magistrates, class 2 magistrate, class 3 magistrate. This is the category. And when we talk about the civil judge, they are simply the judges. Of course, the importance is there in the eyes of the people from the side of the criminal judge or the criminal court, and that is why the district judge is coming from this side most of the time. Most of the time, I'm not saying that it is mandatory. And then this district judge is becoming the senior most civil judge also. Then this district judge is having appellate jurisdiction also with him, that if any of the case is not being heard properly, then he has right to reserve a particular case to be heard by him. And there is no roster system here at the district level. He is the person who decides that which case will go where. Means electronic mechanism or allocation is not there the way we are having it as of now in high courts and Supreme Court. The panels are there, you can see the case when it will come, it will be notified on your mobile also, message will come, right? So that mechanism has not been developed so far at the subordinate judiciary level. यहाँ तक की बात समझ में आएगी. Then apart from Lok Adalat, there are other courts called as FTCs. The fast track courts, yesterday I told that these were developed out of the Finance Commission recommendation, the 11th Finance Commission. 500 crores rupees were allocated to begin with. And recently that fast track court mechanism has been revised to dispose of pending cases, right? The experience again is mixed the way Lok Adalat are working in various states. But in fast track court, the setting up of fast track court is possible by the order of the High Court, the Chief Justice of High Court. Every district must have at least one fast track court. There has to be minimum number of pending cases, then fast track court can be set up. Now fast track court you might have seen for some of the cases, for example the electricity bill, right? And for that purpose Lok Adalat are also held. For example the challan. Have you gone to the court to release your challan or to pay? No, your father or other people must have gone. Challan, vehicle traffic violation and all. And many of the challans are lying like that. Not lakhs, crores. They are not paying. Do whatever you want. Nowadays the kind of standard system is there. The message comes to your mobile, right? It's sent to your mobile and then you can pay by using your credit and debit card. That's how it is. Of course, during Corona time, artificially challans were generated. Whenever means the critical points were set in the cameras and all. If one is going beyond a speed limit and all, red light and all, then challans were frequently generated. During election time, no message will come. You can see the electricity bill also this time. You can take it from your owner. It will be in minus or sometimes very nominal. And after election, you see all the pending scores will be settled. That is how it is done. Apart from FTCs, we are having tribunals. Tribunals, though some of the tribunals have been provided in the constitution itself, original constitution. For example, River Water Tribunal. Indirectly. So Article 262 and Article 263. Right? So whatever the problem between two states is there related to water, it will be decided by the center. Now center was also having its political component. Then the River Water Tribunal, one River Water Tribunal common for all the river disputes. So you might have heard Kaveri water dispute, Krishna Godavari, Ken Betwa, right? So river water dispute is a big issue. Agriculture, and on agriculture it depends that the industry works, the cotton industry, vegetables, everything, even Sensex, right? Then we are having the media court also, or kangaroo court. See, these kangaroo court and media courts have not been allowed by the by the law, but they have not been banned, they have not been penalized, and they have been given tacit liberty, and they are mushrooming. So for example, आपकी अदालत satirically, आपकी अदालत, what what do they do? आपकी अदालत means yours court. There is a serial of a person called as Rajat Sharma. So he invite most of the celebrities, famous people, and just then the case is registered artificially and one artificial judge is hearing. But then if the media is trying a case by inviting some of the panelists, right, and then they are disposing of the case with one decision, then it will be a kangaroo court. Actually, the kangaroo court was first practiced in Australia, but the formal practice of it has been seen in US. In US. Why? Because separation of power. Because 50 states not in parity with each other, having kind of absolute federalism, not obeying one common apex court, federal court in US. The media is more effective, but they are also doing very good. Not doing, but they were doing very good because they were manned and membered by the experienced people the way Lok Adalats are working. So what Lok Adalats we have here, the media is having the same mechanism in US. So on the line of US, we have started doing the same, but we did not get the success, but we just made some of the entertainment element out of it. That's it. But yes, media codes, the kangaroo code works. They have not been banned formally. That the media license will be cancelled of it means of a channel. The license will be cancelled. It has not been done. Then apart from this, we are having village council and the gram sabhas. The village council in some of the backward areas, they have been given some of the judicial powers to give small punishments. So 500 rupee fine, right? Sometimes a stunt death penalty. Then such punishment will be executed? No, it can be appealed. The punishment given by village courts can be appealed in the formal judicial court, in district court, in high court, and in Supreme Court, right? नहीं तो वो दे दिया उन्होंने, फिर क्या करोगे? दे दिया तो दे दिया, अपील तो करोगे. If they have given, what to do, right? So that's how it is. Hmm? Hmm. Kangaroo court is necessarily uh, in effect when we have decided something. But of course, you are saying that some of the evidences media is showing, right? It is helping indirectly the court. Then court may take suo moto uh, observance of it, cognizance of it. That okay, this is the proof. Or otherwise, it will be brought. It will be brought to notice by the lawyer. Lawyer, what will they do? Either they will have the Xerox, the video means the electronic evidences are admitted in court. The judges have been provided with the laptops and the systems with good internet speed. Immediately they Google something and they can see as part of the trial. Hmm. Why parallel courts are running when we talk about, say for example, very famous kangaroo court in case of who was that Baba? Asaram Bapu, right? You know Asaram Bapu? Okay. So very big Baba, whom the chief ministers, even prime ministers, they were taking him in very high esteem. He was having, affair. Having Baba having affair should not be a problem. But the matter was reported by the lady herself, and the exploitation charges were there. Whole image gone, and even followers in lakhs are there of that Baba, because property, if you count the asset, I have not counted nor I have referred to any report, but I can imagine that it must be in tune with like at least 30 to 40,000 crore rupees. What are you doing here preparing for civils? You understand this? So the kangaroo courts, so the money were given to the media that please save Baba's image, right? So the people were also influenced. No, 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 Baba is right. It is artificial. The lady has been given money, right? Then people started showing that if Vikramaditya could not be saved out of Menka episode. You understand Vikramaditya? The Hindu mythological figures, that one lady was sent from heaven, right, to disturb the focus of one of the person who was into the kind of you can say Vishwamitra, no? He, he was having focus on his worshipping cycle so as to get something big which was not desirable by God Indra. So they sent one very beautiful lady to disturb his focus and they were having success in it. So that kind of mythological threats were floated to to woo the people, to convince the people that it is just artificial in nature. So these are all kangaroo courts, but these are not finding much substance in it. But sometimes when you are writing the answer, you can mention it too, right? Because when Lok Adalat is working out of the legal purview, the media courts are also working out of legal purview. So we can write one line. Yeah. So the fast track courts are the special courts. Other special courts are like CBI, special bench is there. Why these special courts are held? To work 24 into 7. To work into 24 into 7 because CBI is conducting the raid, right? And they have to take the permission to take a person on remand, right? To take out the truth. Then the court, without court's permission, you cannot remand a person. That is why the CBI special court, a special charge sheet. And what happens in special court? Basically, a judge is appointed, and it is also membered by some of the retired people. In Lok Adalat, training is not there. Training is not there. The people who had administrative or judicial experiences, they are member of it, and it is headed by a retired judge or a serving judge. So there is no problem at all. Military tribunals. Military tribunals. You are talking about Armed Force CAT, Armed Force Tribunal, AFTs. So armed force tribunals have been appointed on the line of CAT. So what do we mean by tribunals? First of all, in normal Supreme Court, High Court and High Court and District Court, what training they have got? Have they been given special training with regard to IAS, special training with regard to IPS, or special training with regard to the armed force people? No, they are the layman judges. The nitty gritty, right? The fine things of the administration of that service is not known to them, are not known to them. Armed Force Tribunal is membered by the retired armed force officers. And being an army officer, if I am having some problem that I have been exploited by my own force, then I will be going first to AFT. The punishment given by AFT can be appealed in normal court. But then normal court has been given the homework done by the special court. Special court means the tribunal are the expert bodies knowing the things that what all might have happened because they have lived that life. So for example, the river water tribunal, don't you think that engineers must be a member of it? That a layman judge will not be able to understand that what level of river water should be maintained in one dam, or what is the weakness of the wall of the dam, that to what capacity or to what extent it can tolerate the pressure. You understand this? The layman judge may not understand this. That is why the tribunal concept is there. So armed force tribunal is working for those people who are serving into the forces, and it is being heard by those people who have lived the life and are into the retirement mode. Court martial is not by tribunal, but court martial is done by the organized court within the armed forces, and it is membered by the officers. Judges नहीं होते necessarily. Only the senior officers are there. नहीं जा सकते हैं, जा सकते हैं, कोर्ट मार्शल के खिलाफ जा सकते हैं. Generally, I know one of the very close case. So they ask the person who is being tried that what do you want? What do you want? Because same army personnel is being tried by same army officers, and sometimes they have worked together. So what do you want? If it is not a heinous crime like that, if it is a civil offense, like one is fugitive without leave, one has run away from the army, right? Then what will happen? If the court martial is there, even one will be, uh, you know, suspended, or one will be terminated, removed, dismissed. Dismissed means court martialed for the war offense, right? If you have leaked the information, this is the heinous crime in defense against the tribals. So you're talking about the Jammu Kashmir and the Tripura and Northeast. AFASPA, Armed Force Special Power Act. People are generally alleging that the armed forces are not treating us well, because in AFASPA, what happens? Armed Force Special Power Act. No proof is required for arresting a person. So what happens that you're living in Jammu Kashmir, AFASPA is there, the army is having doubt, they will be picking you, taking you to the camp jail. No proof is required, no media report is allowed. Now you are sitting outside the camp, military camp, for days, for years, with the kind of placard, disappeared father, disappeared daughter. You might have seen the movie Heather. क्या हो गया? Heather movie, have you seen? No? No? So in Heather movie, I don't know what. In Heather, ये काम ही नहीं कर रहा है, कर रहा है थोड़ा थोड़ा. So in Heather movie, is it working? Fine. No, it's not working. Of course, the speaker. Okay, fine. Okay. So in that movie, it was shown that how the AFASPA is misused. It is sometimes termed as draconian law, right? So for that matter, if United Nations peacekeeping force working in Congo, Congo, Kenya, the South African countries, the ladies were exploited by the army people sent by different countries. India was one of them. Indian Air Force was one of them. So if you are going ahead, some of the miscreants are there within the civil service also, within IPS also, right? Within police people also. So no body is the exceptional body having 100% pure personnel, or we don't know the circumstances. We really don't know. But yes, a FASPA is a draconian law, but we cannot done away with this, because you don't know the situation there, that even the ladies are used by the terrorist, right? The burqa is used to conceal or hide the suicide bomber kind of mechanism, and they become the suicide bombers. We quit. That is why in the frisking, the United States kind of state take it otherwise, that you will be frisked. You need not to wear the kind of religious symbol uh, oriented cloth like scarf, hijab issue, which was there in India too. Okay, so coming back, The Lok Adalat, yes, Nalsa. They are having Nalsa. I'll tell you about it. The Lok Adalat experiment is not very old. Justice P. N. Bhagwati, if you come to know, Justice P. N. Bhagwati was very good lawyer. So 1982, the experiment started. Lok Adalat. Now it is a successful story. All the civil cases, including the revenue, the tax, the electricity bill, the water bills, are disposed of by Lok Adalat. Right? So can we take one line? You please write subordinate judiciary. Subordinate judiciary from Article 233 to Article 237. Generally in UPSC the question is not covered from this subordinate judiciary, but for information you can take a short note. Write in it, there is two types of there are two types of court at the level of district, namely civil court and session court. Civil court and session court. The civil courts are headed by district judge, followed by additional district judge, comma, civil judge senior division, civil judge senior division, comma, civil judge junior division, civil judge junior division. Right. The civil matters like tax evasion, EVASION, tax evasion, comma, the revenue disputes, comma, family property disputes, etc. are heard in such courts by invoking Civil Procedure Code 1908. Right. The next paragraph. The session codes are for criminal offences related to physical assault and injury, comma, mental torture, emotional blackmailing, etc. It is headed by session judge, followed by followed by Chief Judicial Magistrate, comma, additional CJM. CJM means Chief Judicial Magistrate, additional CJM, then comma, Judicial Magistrate first class, then comma, Judicial Magistrate second class, second class, full stop. In metropolitan area, in metropolitan cities, metropolitan cities, metropolitan metropolitan magistrates are appointed. Metropolitan magistrates are appointed as class 1, class 2, or chief metropolitan judge. Metropolitan judge, full stop. Apart from the district court, lok adalat also hear the cases. Hear the cases. Put the heading Lok Adalat. Lok Adalat. LOK. In exam also it will be like this only for everyone. Though it is a Hindi nomenclature, Lok means people, Adalat means court. Okay. So please write. These are also called as people's court. People's court to provide justice at their doorstep. At their doorstep. The main objective of Lok Adalat, of having Lok Adalat, is to have speedy justice with minimal or no cost at the regional level. Full stop. Lok Adalat have been given a special status under Legal Service Authority Act, 1987, which provides statutory base to it, statutory base to it. Full stop. Lok Adalat has jurisdiction on jurisdiction on civil jurisdiction on civil and revenue matters and revenue matters. Full stop. To solve the cases, conciliation process is followed. Conciliation, CONCILIATION. Conciliation process is followed in place of arbitration, arbitration or dispute resolution mechanism, which is followed in normal court, which is followed in normal court. Lok Adalat is not bound. Lok Adalat is not bound to work under CPC or IPC. CPC or IPC. Because of this purpose, it is membered by legally spirited person, comma, retired administrators and experienced people of the area who are accepted by people full stop. It is chaired by sitting or retired judge. Lok adalats are very successful. In solving marital and family disputes. Full stop. The experiment of Lok Adalat started in 1980s under the guidance of Justice P. N. Bhagwati. Please stop. The first formal Lok Adalat was set up in Delhi in 1985 and then in Chennai in 1986. Full stop. There cannot be any appeal There cannot be any appeal against the decision given by Lok Adalat in any court of India. In any court of India. Full stop. It means the decisions given by Lok Adalat are either accepted by parties are either accepted by parties or or they the decision leave the decision given by Lok Adalat and they register a fresh case in normal court. Case in normal court. Right? Then write criticism of Lok Adalat. Number one, to inflate the number of cases, in Lok Adalat, comma, already settled cases in normal court are referred to Lok Adalat. So that judges feel relaxed and they can demand appointment of more number of judges. They can demand appointment of more number of judges. Then number two, the presiding judge of Lok Adalat means the chairperson. The presiding judge of Lok Adalat have wide 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 discretionary powers. Discretionary means whatever he wants to do, he can. Discretionary powers, which in any matter may be misused for pressurizing and influencing the parties to reach a settlement. Okay, the number third. The lawyer and parties show passive resistance to Lok Adalat by not appearing on the determined date and time. The next point, while Lok Adalat is successful, while Lok Adalat is successful in states like Gujarat, Karnataka, and Manipur, comma, its success rate is not good in other states. The next point, many presiding judges, by giving inflated number of cases, comma, try to boost their self image, try to boost their self image for career advancement and promotion. Then last point, lok adalats are used lok adalats are used for speedy justice, for speedy justice, but in this sense, did you understand what is he saying? How the election campaigns are held in your, means are conducted in your area? There, like this all only? No, very peaceful. People are not even coming to know that elections are being held. Okay. Hmm. So Delhi being one of the most populous area, so this is the scenario. हाँ, bloodshed campaign होते हैं. At the level of Vidhan Sabha also, one MLA is running behind another MLA with gun. There was an MLA I can come to know, Paritala Ravi, in uh, Paritala Ravi was in I think Maharashtra, but another one was there in Allahabad, Dhumanganj Thana. So one candidate was running behind another candidate to shoot him. Because if we are not able to win over another, then this is the way out of the kind of frustration. Because for the election campaign, they sell their house generally. So at least 1 to 2 CR crore, 1 to 2 CR, one candidate is spending. And you see, it is done in the expectation of something uh, like under table money, then only they will be taking advantage. Otherwise, what is the salary or the amount given to the politician at local level, right? So the last point, the lok adalat are used for speedy justice, but in this sense, justice delayed is justice denied concept. Justice delayed is justice denied concept has been replaced by justice hurried is justice buried. Justice hurried is justice buried. Okay. Now, please write about fast track courts, FTCs. write in it. These were created. These were created on the basis of 11th Finance Commission recommendation. 11th Finance Commission recommendation in year 2000. In year 2000 for 1734 FTCs. 1734 1734 FTCs, full stop. It was because of the fact that more than 2 crore cases were pending in district subordinate codes. Please stop. Around 500 CR rupees 500 CR were was approved by 11th FC to set up FTCs. Full stop. On 31st December 2018, there were 699 FTCs. There were 699 FTCs, and most of them were on the verge VERGE, on the verge of shutdown on the verge of shutdown due to lack of fund that they require for new buildings and to pay more number of judges. Let's stop. In Brij Mohan Lal case, Supreme Court instructed that FTCs means fast track court, should not be disbanded overnight. So FTCs were recreated that were disbanded from 2000 onwards. Disbanded from 2000 onwards. Some states want FTCs as permanent features. Full stop. In August 2019, the government has proposed to set up 1023 FTCs 1023 FTCs to clear cases related to POCSO POCSO, that is prevention of children from sexual offences act, right? Full stop. It is because of the fact that has issued direction Supreme Court has issued direction that district with more than 100 cases pending under POCSO need to set up special codes for shortened and simple process. Full stop. FTCs are created by the states in consultation with state high courts. Okay. Now put the heading jurisdictions of court. Types of jurisdictions of court. This type word is also called as head of jurisdiction. Types or head of jurisdiction of courts. So we discussed how many types? The original jurisdiction, then the writ jurisdiction, then contempt jurisdiction, then civil jurisdiction, then revisory jurisdiction. Okay, so we can take note of it. Number 1, original jurisdiction. Under Article 131, the Supreme Court is the sole arbitrator. SOLE, sole means only, is the sole arbitrator to resolve dispute between center and states or between the states themselves. Full stop. The original jurisdiction of Supreme Court is federal in character. Full stop. After 7th Constitutional Amendment Act 1956, 7th Constitutional Amendment Act 1956, the OJ of SC, OJ means original jurisdiction in short, OJ of SC, SC means Supreme Court, does not extend does not extend to an issue that relates to an international agreement or treaty or sanad. SANAD. Sanad means certificate. SANAD. Sanad that was signed or entered into force before the commencement of the constitution, means before 26 January 1950. Okay, then the second one is the appellate jurisdiction. APPELLATE, appellate jurisdiction. Write in it. The Supreme Court is the highest court of appeal on all civil and criminal and constitutional cases full stop. In criminal case, the Supreme Court is bound to hear a case decided by High Court on appeal under the following conditions. Number 1, where the trial court, TRIAL, trial means the hearing court, trial court has acquitted, AQUITTED, acquitted the person, but the High Court on appeal has reversed the acquittal, AQUITTAL, acquittal, and has given death sentence You understood the meaning of it? So for example, the lower court has released you with full dignity attached. You are an innocent person, but the other party went to High Court because you were guilty and the case has been wrongly decided, maybe influenced, and High Court has reversed the acquittal and has given death penalty. Then Supreme Court will take it up. This is the meaning of it. Then second one, the High Court has taken the trial of a case before itself and it has given death penalty. death penalty. Then third one, where the High Court has certified that where the High Court has certified that civil or criminal case is fit to be civil or criminal case is fit to be heard by Supreme Court on appeal on the ground that the case involves interpretation of important question of law, right? Article 133 Article 133 is used for all civil cases and Article 134 for all criminal cases. Criminal cases. Right. Apart from this, under Article 136, a special leave petition SLP, a special leave petition can be filed before Supreme Court to take up the case. What is SLP? नहीं, वो तो आपने लिख दिया. High Court has written that you may go for appeal also. But what is SLP? Special leave petition. Huh. So when the case has been decided or the case is running, but you are not satisfied, and there is no ground, but then a special reason may be there that you are not satisfied, that is subjective. Then under Article 136, you can directly go to Supreme Court. It is Supreme Court who may reject it or accept it. Yes or no? And what is curative? What is curative? CURATIVE. Curative petition. Curative means cure. CURE. What to cure? There is some part of the punishment which to be cured, or you have been convicted. It has to be cured. Then curative petition is filed. Then what is review petition? To review the judgment. So say for example, you have been given death penalty. Your name is Ajmal Kasab. Then first you will follow what? Mercy petition. Now mercy petition has been rejected. Then what will you do? Review petition. Okay, review petition. Then instead of it, what you can do otherwise? Curative, वो तो हो चुका. Mercy petition is pardoning. Curative petition, that some law was left. means some area or some fact was left, and the decision was given in absence of that fact. दो बार review करा, it was requested by the parties, so it will be, that is judicial review. um, Judicial review you are talking about. हाँ, तो that is a judicial review. Mhm. So it is a judicial review. Judicial review. Judicial review is different from review petition. Review petition is not connected directly to any policy and program and any law. The review is with regard to the punishment. Whereas MPLAD kind of thing, these are not the punishment, but you are reviewing the law and you are checking its constitutionality. Right? Now please put the heading advisory jurisdiction, Article 143. I did not mention. Advisory jurisdiction. Write in it. The President may refer an issue of law or even a fact which is of public importance to the Supreme Court seeking its opinion on the issue full stop. the expressed opinion the expressed opinion by Supreme Court is not binding on the President, full stop. After 7th Constitutional Amendment Act CAA 1956 if the advice has been sought by the President related to international agreement or treaty signed before 26 January 1950, the court is bound to give its opinion. The court is bound to give its opinion, full stop. But on other issues, court may not give its opinion. Okay. The next point, revisory jurisdiction. Write in it. The Supreme Court, being the highest court of appeal, comma, the Supreme Court being the highest court of appeal, comma, all its judgment or decisions are automatically binding on all courts of the country, but Supreme Court is not bound by its own decision under Article 137, Supreme Court enjoys revisory jurisdiction for a stop. In exercise of this jurisdiction, Supreme Court may correct any mistake Supreme Court may correct any mistake or can revise or it can revise the whole judgment. It can revise the whole judgment. The next one is contempt jurisdiction. CUNTEMPT, contempt jurisdiction. Write in it. Under Article 129, Supreme Court and High Court are court of records. And it is mandatory for all individual, organization, government, and ordinary courts to obey the decisions given by the court. Right. Any disobedience will be considered as contempt of court. Right? Contempt of court. Then write writ jurisdiction, WRIT. Next one is writ jurisdiction. Write in it. Under Article 32 and 226, under Article 32 and 226, Supreme Court and High Courts protect the fundamental rights of a citizen as one may directly go to Supreme Court or High Court under writ jurisdiction. Right, then right below this, the jurisdiction of Indian Judiciary has been expanded substantially by way of PIL and judicial activism. PIL and judicial activism, and also because of doctrine of basic structure. Doctrine of basic structure, right? So this is what we have. Okay, समझ में आई थोड़ी सी बात? Understood little things. Now the next issue the small issue is of CAG. CAG means Comptroller and Auditor General. You know the meaning of comptroller, not the controller, right? What is the meaning of comptroller? Hmm? What is the meaning of comptroller? Who is not the controller is called as comptroller. जो देख सकता है कर नहीं सकता, can see but cannot do anything. Comptroller is the one who approves the amount to be withdrawn from the fund, means the consolidated fund of India here. And controller means the one who controls something, right? So comptroller and auditor general. Comptroller means before the money has been taken out from the treasury or the fund, and auditor work is coming after the money has been spent. As the post-mortem report, the auditor report is made, right or wrong? So for example, the 100 rupee money is to be withdrawn from your father's pocket. Who will sanction this? Who will be the comptroller here? Either father, mother, not at least you or your elders, conspiracy partner. Yes or no? Now 100 rupees has been spent in purchasing toffees, the biscuit, the crackers, or holy colors, or whatever the fantasy is, comics. In the childhood, these were the things for which money was not given. Now the auditor report will be submitted that what all has been purchased by the 100 rupees. So it will be post-mortem report. You cannot do anything, money cannot be reversed. So before conducting the post-mortem report, what is to be done? Pocket money is to be controlled. The report is to be submitted that for which purpose the money has been taken. In India, it is not done. That is why CAG is only AG, is not CAG. But this work is done in UK. So in UK, CAG is CAG. But here in India, CAG is right? Under Article 148, CAG is a constitutional body and he doesn't work under the pleasure of the president. He enjoys the status of a Supreme Court judge. The way Supreme Court judge is removed, CAG will be removed, it at all it is happening. Rest of the provision we will see tomorrow. Okay. नहीं. CAG is a constitutional post, generally for 6 years or up till 65 years of age. It happens in case of Attorney General, who is the lawyer from the side of the government. So every body needs a lawyer of their own choice, right? So see you tomorrow.